your lordship appreciate my urgency and directed it should be the top of the list, my lord. And there's a clear direction to the court officer, but it is downside of the list. My humble prayer, my lord.
Wait. I think up to item 24, it is only condoned delay. Huh? So you wait for some time.
Yes, I don't have a problem during the course, only prayer during the course of the
Let us see how we progress. Yes,
Lord's kind leave to mention for inclusion of a contempt matter. But the judgment was passed when my lord was sitting with Justice Bhattacharya.
you give them.
May I hand over?
Next week we will constitute the bench.
I'm so grateful.
May I, Your Lordship, kindly to mention one matter. I appeared on behalf of the
Your name is not there. You put his name in capital letters.
No, my lord.
Yes,
Left
please.
side daily list under the heading for judgment, serial number 1.
I appear on behalf of the appellant.
For the respondent, one lordship.
Accordingly, the appeal stands dismissed. The order passed by the learned single judge is hereby affirmed.
Extremely pleasure.
Yes.
Original side daily list, item number 1.
But I am for the appellant. My lord,
How many
this
days?
matter, my lord.
My lord, I appear for the respondents mostly.
My lord, there's a section 5 application. Your lordship will recall. We had filed a, my lord,
Review, huh?
no, my lord. We had filed a, my lord, cross objection to their appeal, to the state's appeal. This is regarding, my lord, whether stamp duty is payable
Yes.
and if at all, at what rate with regard to a scheme of amalgamation.
Their appeal is already.
There is appeal. We had filed a cross objection, but your lordship's view was that you file an independent appeal because it should be allowed.
Only predicament, my lord, this appeal, my lord, is.
No, the cross objection was within time.
Yes,
This was within time,
absolutely.
but this appeal is around 2000 days delayed, my lord.
But there are 800 days delay, my lord.
800 and 200, my lord.
We did not even file, my lord, on that basis that your lordship will consider.
2000 days delay.
Well, it's a question of law. It has to be set my lord, at right by your lordship.
2000 days delay, my
Kindly,
lord. Should
my
be
lord.
kindly appreciate.
There 800 days delay, we did not even file an objection. That, my lord, will
2025.
show some magnanimity.
Filed by the appellant writ petitioner to condone the delay of 2098 days in filing the appeal. We have heard the learned advocates for the parties. The learned government counsel, the learned senior advocate appearing for the respondent state would vehemently oppose the delay. Considering the peculiar facts and circumstances of the case, we are constrained to exercise discretion in the matter. We say so because, as against the impugned order, the state had preferred an appeal in APOT number.
My lord, that is your lordship's orders is at, my lord, page 26, where your lordship has condoned. That is APOT number 140 of 2021. 26.
28.
APOT
26 and 28. 26.
140 of 2021. And the said appeal filed by the state was also barred by time. And there was a delay of 830 days in filing
My
the
lord.
appeal.
We did not even file an objection.
While condoning the delay by order dated 12th April 2023, it was observed that though the reasons are not fully convincing, since a question of law was involved in the appeal, the discretion was exercised and the delay was condoned subject to payment of cost. The present appellant writ petitioner had filed a cross objection in the appeal filed by the state, and the court opined. No, sir, before that. Subsequently, by order dated 1st May 2023, the appeal filed by the state was admitted.
My lord.
The appellant writ petitioner had filed a cross objection in the appeal filed by the state, and the court opined that since the grounds canvassed were independent grounds canvassed by the cross objector are required to be canvassed by way of a separate appeal, leave was granted to the present appellant writ petitioner to withdraw the cross objection and to file a separate appeal. This is how the present appeal has been filed. No doubt it is true that the delay is enormous, but considering the fact that the appeal filed by the state was admitted, appeal filed by the state with a delay of 830 days was condoned, and the appeal was also admitted on the ground that a question of law is involved in the matter. We are inclined to exercise discretion in this instant case and accordingly allow the application and condone the delay in filing this appeal. Let this appeal is admitted. No, let this appeal be tagged along with APOT 140 of 2020.
They will not be subjected to any cost.
Cost we will pay.
We paid 25,000, my lord, for 830 days.
Condoned, subject to payment of cost of rupees 50,000 payable to the State Legal Services Authority, West Bengal. Cost shall be remitted within 3 weeks from date.
Well, the matter, I believe, is coming up next week, next Friday, if I'm not wrong, the main appeal.
Let
Whenever
it come on
comes
that day by then.
So both the appeals will come up together.
up, so deeply. And grateful to my landlord.
Yes, next.
Item number 2.
2 and 3, my lord, service has not been affected, my lord.
You are taking notice?
My lord, we have not received the appeal copy. So, my lord, if they could kindly serve us with
We
the
will
appeal
condone
copy.
that only 29 days.
The delay may be condoned.
We have heard so and so, so and so. Ms. So and so accepts notice for the respondent assessee. There's a delay of 29 days in filing the appeal. As the reasons given are satisfactory, the delay is condoned, application allowed. You please serve copies right away.
In course of the day, my lord, we shall submit. 2 and 3, both.
2 and 3, sir, separate orders.
Grateful, my lord.
Item number 4.
I am for the appellant, my lord, if you can serve.
My lord, I am for the respondent.
Hmm.
The first thing is that I am not aware how many days is delay.
My lord,
Because the delay application is having the blank in every places about the date.
89 days.
89.
Now the second thing is the appeal itself is barred due to the monetary limit. It was a claim of 10 lakh rupees only.
Hmm.
I can show from the order in original because they have not enclosed any other document.
My lord, the documents being of 2009,
I'm sure.
I would.
Then
Three
we'll
for-
do one thing. Today we'll condone the delay,
Hello.
record Arjit's objection. You get written instruction from the
My lord,
department.
my lord, deeply obliged, my lord.
So if you heard so and so, Manasi, etc., Arjit Chakraborty, there's a delay of 89 days in filing the appeal. As an explanation, delay condoned. Learned advocate appearing for the respondent assessee submitted that the appeal cannot be pursued by the department since it is below the monetary limit. Let written instruction in this regard be obtained by the learned advocate appearing for the appellant department. Next week, next Friday.
My lord,
Next
my
Friday.
lord. My lord, the affidavit.
My lord, may I be please permitted to file the competency and vakalatnama on behalf of the respondent?
My lord, the affidavit of service can be kept with the record, my lord.
Instead of next
Affidavit of
Friday,
service.
let it come on Wednesday. Wednesday we take 2 p.m. Also. Next.
Item number 5.
For the respondent, my lord. Kept it on 26th.
No. Second.
Second.
You don't want second?
For the respondent was a delay.
Then 4th April.
4th.
There's
They
a
are-
150 days delay, Mr. Dey.
150 days delay, my lord, but I am not opposing, but it is the order of the court, my lord, I am able to oppose.
We have heard Mr. Vipul Kundalial and a senior advocate assisted by so and Mr. A.K. Dey, learned advocate appearing for the respondent assistant. There is a delay of 150 days in filing the appeal. The
I
prayer
voted
for condemnation of delay is vehemently opposed by Mr. Dey, appearing for the respondent assistant. We have perused the affidavit filed in support of the application and we find the reasons stated therein are convincing. Therefore, the application is allowed, delay is continued. Next.
My lord, it's the same.
Same, my lord, I am opposing there.
Yes,
Same
same
order.
order. Item 7 also.
But let it appear when? It will appear. Briefly appear.
My lord has condoned the delay.
Yes, condone, delay condone, तो बोले ही थी।
Next.
Item number 8.
Service is.
No. He's appear.
This is that gold.
My lord, contempt, yes, my lord. Gold contempt application, your lordship had directed pursuant to order of the tribunal 3 weeks from the date of furnishing of bond and bank guarantee.
Have they filed an appeal to Supreme Court?
No, no.
My lord, 7 matter, item number 7 was different matter, my lord.
7 is different, madam.
Yes, my lord.
Item 7, they said same.
My lord, item number 7, I am appearing.
How many days delay?
My lord, the service is,
Service not
No.
complete. All
complete.
right, item 7, list after completion of service of notice on respondent. All right, item 8,
Item 8, my lord, we have for the department, but my lord, we have the instruction, my lord, department is went to the, my lord, is going to the Supreme Court. For preparing SLP
when
paper.
you are going to the Supreme
My lord, they are, my lord, your lordship knows, my lord, department has some takes some time, my lord, because they are really, my lord, they have ready to, my lord, send all the papers to the Supreme
No,
Court.
no, you please show some letter saying that
My lord, kindly,
it's a fit case for appeal.
my lord, adjourn for 7 days, my lord. I will come back.
So they will not comply with the order.
No, we shall comply. Why not, my lord?
Because they are filing a Supreme Court, they are saying that I will not comply with the order.
My learned friend waited
So
for
let
long
them
time.
comply
For
with the
7
order.
days, I think, my lord.
All right, one chance we will give. Mr. Udeshankar Bhattacharya,
February.
standing counsel
Yes.
accepts
So that
notice.
3 week
who is
expired.
assisted by Mr. Supan Banja. For the respondent, no? We have heard Mr. Mainak Musk, a senior advocate for the applicant. It is submitted by the learned advocate appearing for the respondent department that the department is proposing to file an appeal to the Honorable Supreme Court as against the order dated 19th February 2025. However, in this regard, there is no written instruction given to the learned advocate for the department. Let appropriate written instruction be placed in this regard on the next hearing date. List the matter on 2nd.
Second.
Get from it.
So, my lord, your lordship said written instruction. They will come with a letter saying that they propose to file Supreme Court. Now, when will they go?
That we will decide. Next.
Tax matters, item number 9.
Your Lordship, I am appearing for the respondent in this case. Need time to file wakalatnama in this case. Your Lordship, we have.
No delay.
My Lord.
And it's a ordinary Black Money Act.
Blood subject to blood. Blood, we have blood on short submission.
Where is that Madras High
My
Court?
lord, my lord, only one submission. My lord, in this matter, my lord, your lordship, kindly see, my lord, I have handed over the original order copy of the learned tribunal. Your lordship, kindly, my lord, come to the, my lord, page. Just a minute, my lord, page.
Your Lordship, we have been not served with the copy. Kindly.
This is my order copy of the tribunal. It is not that, my lord, he has not no knowledge, my lord. Lordship, kindly see, my lord, page 8. Sorry, my lord, not page 8. Just a minute. Just 1 minute. my lord, page 21.
Hmm.
My lord, page 21.
What is page 21?
My lord, this is the my lord, order of the learned tribunal passed on 29 February 2024.
Hmm.
But in this order,
Hmm.
the learned tribunal was opined that the assessee has to file bank account of 3 bank account. Here, my lord, only 1 bank account of State Bank of Singapore has been filed, and my lord, ultimately by the final order, the State Bank of Singapore, the bank account has been taken consideration of the tribunal. But in this order, my lord, your lordship kindly see, my lord, page 21. My lord, may I place this order, my lord? While dictating 1, 2, 3, 4, 5, 6, 7 line, the appeal was heard on such and such date. While dictating the appeal, it was observed that there was some important document information explanation which were required to be examined in order to complete the order. We observe from para 7.5 of the assessment order, wherein the assessing officer has stated that the assessee has remitted the import profits of 3 bank accounts, namely State Bank of India, Singapore, Citibank of Singapore, and UCO Bank, Singapore, to Messrs. RB Global P Limited. The assessing officer also noted that these remittance were made through various entities, companies. Thereafter, middle portion, we note that the copies of the bank statement of Citibank of Singapore and UCO Bank of Singapore are not placed on record, whereas the copy of bank account of State Bank of India, Singapore is available in the paper book. Besides the certain other issues, we are required to clarify which are stated herein under. Therefore, we direct the assessing to furnish the following information: copy of bank statement of this bank right from the date of opening till date, Citibank and UCO Bank of Singapore. Status of any pending inquiry, but this is non-relevant. Thereafter, my lord, next page 23. My lord, middle portion, below to the middle portion, as on date of framing of assessment, only 1 bank account of State Bank of India, Singapore was sent to the assessing officer, which has been stated in the assessment order. Learned dear also directed to apprise the bench about other pending cases. That is not relevant. But here 3 bank account is there. Only 1 bank account the assessing officer can open with the code, because the assessing officer had only 1 code. 2 code was not given to the assessing officer. Assessing officer not able to decode 2 bank account. Thereafter, step has been taken to send the matter to competent authority to get the code. That is also appearing in the next order of the tribunal. But the learned tribunal surprisingly, my lord, only go to the 1 account and assess and hurriedly pass the assess order. We are responsible submission before lordship. Let them file Vokaratnama. Along with, let them file the account statement of 2 other bank accounts. Because 1 bank account, there is a balance of 1.
First, let him file the Vakalatnama. Then
Yes.
only he can legally represent the. No, are you carrying that decision of the Madras High Court which they followed? The tribunal has followed the decision. It's an unreported decision, I think, in Srinidhi Karthik Chidambaram.
Which page?
In fact, in your grounds, if you see your memo of P.
Yes, my lord.
Where did I see? Page 8, ground number E. E for elephant.
Here, this is separate, not in the human error. They are saying they have not filed in the ITR. They have.
That we'll consider.
We will distinguish it. We will.
No, are you carrying that
No,
decision?
today not right.
You should have enclosed it along with it, or at least given us copy. It should be reported by now.
Yes, reported.
Can we search? But it is Madras High Court decision. It's part of the category 1, right? India
These matters were before Justice Om Naran Rai. And after his lordship's elevation, they have been transferred to me.
So you get ready with the matter.
So I need some time to get ready.
Earlier, you have not dealt with the Black Money Act.
No.
App থেকে করো, তোমার মুখ থেকে করো, তোমার মন থেকে করো।
I feel occasions I had an opportunity to deal with
শ্রীনিধি কর্তি চিদম্বরম, কার্তি না কর্তি? হুম।
But the tribunal doesn't refer to this direction.
No, my lord.
But this direction was issued on what date?
The bench was changed, my lord. Earlier it was heard by the C bench.
29th February 2024.
Yes.
But thereafter the case was argued.
Yes, was argued, but surprising.
That order whereby three bank accounts were referred to was passed by a different bench.
Oh.
And the subsequent bench did not even consider that order. So in this case, perhaps the lower court records.
You see who's the person
Lord, I
who
have-
delivered the judge.
I have seen the order, my lord. I have seen the order in my tab. Order was there, my lord.
You
But I
may
have not
take a
print-
printout. How many pages, sir? So will it be proper for me to hear?
My lord, we will, my lord,
No, this
Lord,
our
this is
judgment
not applicable to this, my lord, in this case.
The
as
facts
a
of
single
this
judge, but what happened to the, I think I dismissed the writ petition. Huh?
The facts of this case are different from that.
This, my order was reversed by the division bench.
My lord, here, my lord, facts is, my lord, different.
But this is single bench order. Division bench order is there. WA 1125. Yes, this one. One second. Yes. You referred to the single bench order also, whereby I dismissed the writ petitions. That was reversed.
My lord, that was also, my lord, relied by the tribunal. That's why, my lord, we have.
That is where asset is purchased in a foreign country or something like
But here, my lord, your lordship, kindly see your lordship order. That is, the question was framed, was that the writ petition questioning the competence of the principal chief commissioner of the income tax Tamil Nadu and Pondicherry to sanction prosecution to file the complaint against the writ petitioner. That is the question number one. And question number two was WB number for issuance of declaration declaring that principal director of income tax investigation Chennai, respondent number two, is not the authority having jurisdiction competence under section 55 of the Black Money Act.
so.
And
That issue doesn't arise.
no,
All right. We have heard so and so. Mr. So and so, learned advocate, accepts notice for the respondent and prays time to file wakalatnama and get instructions from the client. Let copy of the appeal papers be served on the learned advocate.
well, we have sub. If it service is there, well, we have sub. They have received also. Well, they have instruction, they have received.
Strike out that. Give a date after 2 weeks, by then you get ready.
Also, let them file the paper book. They have filed before the tribunal.
On that day, we You can get those documents, no.
But see, these two accounts have not been placed, not the assessing officer, not anybody else. My lord, how can we?
We will
Lord?
file the paper.
We'll issue a direction
Hello.
here. Sir, please give the case file. It is pointed out by the learned senior standing counsel appearing for the appellant department that the learned tribunal had heard the matter on various dates, and on 29th February 2024 had directed the assessee to furnish the following information.
But the copies of the bank statement of bank account.
No, page 22 is the direction.
Yes, direction. My lord.
Following information. From the page 22 of this. Sir. A, B, C. Up to page 23. A, B, C. It is submitted that though such was the direction issued by the learned tribunal, the said information was not placed before the learned tribunal by the assessee, and without noting this aspect, the tribunal proceeded to pass the final order, which is impugned in this appeal. Since there was a direction issued by the tribunal, the assessee was bound to furnish the information. Therefore, we direct the assessee to file a compilation of all the documents which they had placed before the learned tribunal, and also the information, the above information, which was directed to be filed by the furnished by the assessee. Give a date after 2 weeks.
Item number 10,
There is delay of 145 days, my lord. Was served.
My lord, I am appearing for the respondent. My lord, we have not received a copy, my lord.
I'm handing over because with
It has, my lord,
remark
written on,
saying addressee left.
saying that the address
PRCL,
left.
PRCL.
Yes.
You could take a president for the division bench also. Reverse manner.
This appeal is
145 days, Mr. Sen, will control. You give copy.
Yes.
they are giving.
Right.
Oh, with the cover.
No, it
You
has
have heard
actually
Mr. Tilak Prithujoria for the appellant department. Mr. Anando Sen, learned advocate, accepts notice for the respondent. There's a delay of 145 days. Same order, sir. Condoned. Next.
I'm grateful.
I'm deeply grateful.
item number 11,
But I'm appearing, my lord. There's a delay of 45 days, my lord. 45 days delay.
Kejriwal won't oppose that. What is the issue? 68.
68, my lord. But merit bill, we have a case, my lord. It's not.
Meritorious case.
My lord, if your lordship will kindly seize, my lord. First, the assessment order, my lord. It is up. But if your lordship will kindly come to my lord, the CIT's observation first, my lord, page number 13, my lord, facts of the case. But here they have introduced money, my lord. They don't have.
Come to page 37, para 7.
My lord.
1617 shares were issued to the same parties,
My lord.
accepted by the department.
Yes. But my lord, the money is of a director, somebody else's, my lord, Dhanuka. That is the 131 notice was issued, my lord. They have said, my lord, it's my lord, the genuineness, my lord, the money has not been proved, my lord. Lordship will kindly see the CIT's observation first, my lord. If Lordship will kindly up to page number 13, my lord, CIT's observations. My lord, paragraph number 2, facts of the case, my lord. If your lordship kindly sees, my lord, the SSC file is written such and such, my lord, I'm skipping, my lord. Thereafter, summons under section 131 of the ITF was issued and sent to the director and the subscriber of the company. If 11 directors subscribe, Mr. Manish Dokania, the respondent directors of the companies, and Rajiv such and such as director of the company appeared whose depositions were recorded under the oath, and they were held that the assessee was unable to discharge the burden of proof of the substantial claim of the introduction of fresh capital, and on successful and correct analysis of the statement of record, it was held that the share capital along with the share premium is nothing but a assessee's own money contributed on the garb of a share capital into the books of accounts. The appellant assessee hereby submits that the above contentions made by the AO is bad in law, and as well as the facts of the case similar, whom the surmise. But my lord,
Sir,
the notice,
the CIT appeals order is 22 pages.
my lord.
Out of 22 pages,
Yes.
20 pages is the extract of his what is it? Facts in form 35.
Yes.
Then his submissions.
Yes, yes, my lord.
Then
his
his written submissions.
his
then the
conclusion, page number
judgment.
31, my lord.
Therefore, the tribunal rightly observed that simply they can you show the AO's order.
Lordship will kindly see. AO's order, my lord, starts at my lord page number
My lord, page number
9. Page number 9. Lordship will kindly see AO's order. Page number 9. But it is observed the assessee company has shown receipt of the fresh subscription of share capital introducing share premium of rupees 2 crore such and such, fresh premium of such and such. For the purpose of our verification, the examination of the existence and creditworthiness of the share subscribers, genuineness of the share subscribers, and the transactions claimed by the assessee company, further summons were issued and sent to the directors of the share subscriber from whom the assessee has claimed to have received the share capital and share premium at the address given, Lord, available on the record were provided by the assessee. Directors of the share subscriber company were was duly requested to appear personally along with a complete set of books of accounts and document subscriptions of their identity, creditworthiness, and the source of the funds of the subscriber company to make payment of the share application money, the address of the assessee company, and the genuineness of the share subscriber company of the transactions claimed by the assessee company. In response to the shared notice, the directors of 6 share subscriber companies whose depositions were recorded under oath from the above shown statement of directors share subscriber companies, the following issues noted and discussed below. The assessee company has been incorporated in this assessment year 14-15.
That the tribunal says is wrong.
My lord, it is a
But
wrong.
that
My lord,
is-
it was
but
formed in
the-
2011, 26/8/2011. My lord, this is the
That is why the tribunal says.
assessment had been done on this for the assessment year 12-13. My lord, the assessment order was against me. Then, my lord, the CIT appeals passed an order in favor of me. And, my lord, now they have preferred an appeal which is pending before the ITAT on this same self issue for 12-13. My lord, he's saying that it is 2014-15. My lord, this is wrong. It was formed in 2011.
So 12-13 is still pending.
It is pending before ITAT. My lord, CIT was in my favor. So the department has filed an appeal before the ITAT in 12-13. And 16-17, my lord, I have handed over the assessment order. That was in 2018. They've accepted no further steps. That, my lord, I'm submitting this upon instructions.
So this was taken note of by CIT appeals for 12-13.
My lord, that was taken note of by the CIT appeals in 12-13. My lord, I have the order.
But here, my lord,
My lord, kindly, my lord.
But then what more they can do? They responded to the summons. They have given statements.
My lord, they have not considered
the
the
source of
entire
the money,
set
my lord,
of document which has been filed.
And he has given
lord,
so
he has
much
done
of
this, my lord.
details.
He is proceeding on the
But-
basis that it has been formed in 14-15. In fact, my lord, my written submissions before the CIT in this case was that they have just extracted the 12-13 order in which the assessment order was saying that this is the first year. My lord, he's writing it is incorporated in the 14-15. My lord, assessment has been done. My lord, may kindly have a look at this order.
Okay. My lord, if your lordship kindly says, my lord, there
My lord, these are
unaccounted
matter of
money were
records.
introduced in the garb of a share capital. My lord, that is the
My lord,
my
they've
lord, that is the
accepted in
lordship.
16-17. The same transaction they've accepted in 16-17.
No, this is a
And my lord, this
14-15.
was no money introduced by them.
But that is the categorical finding of assessing officer as well as CIT. Lordship will kindly says page number 31 and 32.
Without anything. My lord, page
Lordship will
13, what my learned friend was reading.
31 and
13
32.
of the
Lordship will-
CIT. My lord, that was my statement of facts. My lord, that's my statement of facts which has been extracted.
So this is Delsi.
Delsi, my lord, they have invested in Delsi. My lord, may kindly see what assessing officer is saying. My lord, he's saying we don't know what is Delsi. My lord, it is the second largest luggage industry after Samsonite. He says, I don't know what Delsi is. He's suspecting it on the basis that 1415 is my year.
In fact, if you see the CIT appeals order,
My lord.
just he has handed over just now for 1213.
My lord.
Internal page 8.
1213. Yes. my lord.
1213.
Yes.
The portion which is in italics.
Internal page 8. Yes.
The renowned company, sir.
Yes.
And there's investment at a premium of rupees 90 per share.
My lord, that is also backed by the valuation certificates.
Yes, that is also noted.
That is also the, my lord, it
Sir,
told.
please come. We have heard so and so and so. There is a delay of 45 days in filing the appeal. As the explanation offered is satisfactory, the delay is controlled, application allowed. Para. This appeal filed by the department under section 260 cap A of the Income Tax Act 1961 is within bracket the act is directed against the order dated June 24, 2024, passed by the Income Tax Appellate Tribunal C Bench Calcutta in ITA number 709/KOL/2023 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Page 4 and 5 ABC. After we have elaborately heard the learned advocates for the parties, we find that the issue to be decided in the case is whether the assessee was able to, whether the assessing officer could have invoked section 68 of the Act and treated the amount of rupees 2,91,60,000 as unexplained cash credit found in the books of accounts of the assessee during the year ended 31/3/2014. The assessment order passed under section 143 within bracket 3 dated 27/12/2016 was affirmed by the appellate authority, the National Faceless Appeal Center, by order dated 7th June 2023. Challenging the same, the assessee preferred appeal before the learned tribunal. On perusal of the order passed by the learned tribunal, we find a thorough factual exercise of, we find that the learned tribunal has thoroughly examined the factual position and noted that the assessee has filed evidence comprising of copies of the income tax returns, audited accounts, share application forms, share allotment letters, bank statements, memorandum of article of association, etc., in respect of each of the subscribers before the assessing officer as well as before the appellate authority. Furthermore, the tribunal noted that the assessing officer issued notice under section 133 within bracket 6 of the Act, which was duly replied by the subscribers who by furnishing all details as called for by the assessing officer. Apart from that, summons issued under section 131 to 6 subscribers was complied with, and all those persons who were summoned confirmed the transactions/investment made by them. Furthermore, the tribunal noted that for the assessment year 2016-17, shares were also issued to the same parties which were accepted by the revenue to be genuine in the assessment proceedings, which was done under section 143 within bracket 3 of the Act. The tribunal also took note of the valuation of shares as made by SDP and Associates for the purpose of section 56 read with rule 11 capital U capital A of the rules, and noted that the premium computed at rupees 95.
That will be 95.27.
95.27
because of the stamp
per equity share. And as a matter of fact, the shares were issued at a premium of rupees 90 each. Furthermore, the tribunal has held that the assessee was justified in issuance of the share capital at premium as the money collected were to be invested in Messrs. Delsi India Private Limited, which was a joint venture with Sapphire Trade Associates, the respondent assessee, and Messrs. Delsi India Private Limited with 49% and 51% share respectively. That apart, the tribunal has pointed out a factual mistake committed by the assessing officer, stating that the assessee company is a newly formed company in the assessment year 2014-15. The learned advocate appearing for the respondent assessee has produced the extract from the website of the Ministry of Corporate Affairs, from which we find that the company was incorporated. Where do you get the incorporation date?
My lord, the date is 26/8/2011.
Where? Yes. The company was incorporated on 26/8/2011. This factual mistake has ultimately led to an erroneous order passed by the assessing officer. Apart from that, in respect of identical transaction, during the assessment year 2012-13, the assessing officer held against the assessee and made the addition under section 68 of the Act. This order was put to challenge before the appellate authority, and by order dated 18th April 2024, the appeal filed by the assessee was allowed. Thus, we find that the tribunal has rightly granted relief to the assessee, and there is no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal fails and is dismissed. Next.
Number 12.
But I'm appearing with this delay of 314 days, my lord.
But I've just received the brief, Your Lordship.
You will file affidavit?
My lord but I've never opposed before, my lords. I've only requested that a formal objection just.
There's a delay of so and so. Mr. Pratish Junjanwala, learned advocate appearing for the respondent assessee, would vehemently oppose the delay. After considering the facts and circumstances, and more importantly, noting that this is an appeal preferred under section 260A of the Income Tax Act 1961, wherein the court is required to consider whether any substantial question of law arises for consideration, we exercise discretion and condone the delay in filing the application.
Grateful, ma'am.
Item number 13.
We don't have the police.
How many days delay, sir?
43 days.
That, Mr. Dutt won't oppose. Condone.
Very grateful. Well, next matter, same
Next
issue
matter also same.
and same period.
Milord, we don't have copies, Milord.
Can you give copies?
We'll serve another copy.
Let copies be served. No, we will not record that. Item 13 and 14 condone. Next.
Item number 15.
Yes, Mr. Amit Sharma. How many days? Hong Kong Dragon.
Milord, this matter I'm also happy. Milord, this matter, Milord, perhaps, Milord, there was some mistake in calculating the tax effect. Because the tax effect is supposed, because the differential of the income is 2 crores 21 lakhs. And the tax effect would be less than
in this case, it is not 5%.
So, Milord, we have sought for instructions from the department. Kindly take it up next Friday.
Today condone the delay.
Yes.
All right. Delay condone.
Kindly record the instructions. Right.
He will get written instruction. No,
but item number 21 and 20.
Same.
But actually, when there it is the same matter for
Cathay Pacific matter, Milord, your lordship has admitted the Cathay Pacific 2 matters. Your lordship has
on
admitted.
Wednesday.
It is on the same.
So 21 we will admit. 21 there's a delay.
Yes, my lord. There is 21. There is a delay, my lord.
Right. 21 we can admit.
Delay of 249 days, my lord.
All right. And what about
140 the
23, your lordship.
What is 23? Cathay Pacific.
But assessment years, my lord, in this 21 is assessment year 2016-17 and 23 is assessment year 18-19. My lord, the same matter has been admitted by my lords earlier and also on Wednesday, my lord, which Wednesday was assessment is 17-18, my lord. If it may be tagged.
Sir, item 21 and 23 delay condoned, sir. Admitted on the following questions. Tag along with ITAT 69. Note the appearances.
That meant the formal objection of delay, objection to delay.
Yes, yes,
suggested.
21, 23.
21, 20.
Next,
I'm grateful, Your Honor.
17,
Item number 16.
16. How many days?
I just received.
Service complete?
197 days.
Ah.
197.
Service
Yes,
complete? Who appeared for the assessee before the tribunal?
Well, item delivered on.
Yes, service is complete.
Not
Mr. Surana is here. What is his junior's name, sir?
Bhaskar.
Huh?
Bhaskar.
Where is he?
Well, he was here.
He was here, I think.
Yes, yes. He was.
All right. We have heard so and so. Notice has been served on the respondent. Affidavit of service has been filed. However, none appears for the respondent. There is a delay of 197 days, properly explained to condone. Next. Next is also
I'm grateful.
same.
Item number 17.
Just got the brief. That's why I could not appraise, Your Lordship.
17.
17 is Malad.
What is
Malad, there's a delay of 251 days.
that? You won't
No, no, I'm not opposing the delay. Because if you go to the order of the ITAT, they have only gone on the 148. And the
Next week we will do it. Delay condoned. Next.
Item number 18.
Same assessee condoned. You mark the appearance of the advocates. Next.
Item number 19.
assessee মানে respondent কপিটা দিবি তো
But I am happy.
কপি হার্ড কপি
No delay.
26.
But we have also served.
It is 176.
the client has received the copy have been instructed to appear before lordship kindly fix the matter next week মানে any day
What is that?
Affidavit of service.
দেখিনি তো পড়িনি
All right. So and so, Avram has been done. Delay condoned.
how many days delay
176 day delay. The application.
But they are saying
176.
নামটা লিখে দাও
176. Initially, no
okay.
delay.
All right. 176 days.
176.
no
Delay
I'm not
condoned.
opposing great
Next.
Item number 20.
There's a delay of 138 days.
Sitting in the courtroom 16.
Everything is service allowed.
Central. Respondent.
But we have served. But it has stated in the delivery report out of delivery on 10/3/2025.
Fresh notice. Fresh notice to the respondent. In addition, notice shall be served through email in the registered email ID of the assessee. Next.
Milad, when is it returnable?
We'll have it a week after 2 weeks.
Item number 22.
21.
Item number 22.
22 my lord, I am appearing.
22, Sun Plant Construction, Principal Commissioner Income Tax, Central 2, Kolkata. 559 days, Someone.
Here, my lord, the delivery report not saying that it has been served. My lord,
You come to page 66, para 5. After perusal of the above order, we confronted the learned DR as to how the penalty under 271D can be imposed on the assessee in these given facts. He was unable to controvert the findings of CIT appeals. Pertinent observed penalty under can be imposed upon assessee accepted any loan or deposit or otherwise than by account pay check or so and so. For the facility of reference, we note 269 SS. First appellate authority examined this aspect, observed the assessee accepted the share application money and not any loan or deposit. Share capital is irreversible entry. It is not to be repaid. Similarly, first part is relating to expenditure incurred by the group. Intra-group service also not a loan. Presumably failed to construe the transaction as well as the meaning of so and so. Factor is principal CIT admin who was given permission failed to appreciate the order of CIT appeals before the authorization of revenue.
but here, my lord,
It's unnecessarily waste of resource. There is a delay of 559 days in filing the appeal. We have perused the affidavit filed in support of the application and we find the reasons to be that no cogent reasons have been given to explaining as to why the appeal was filed belatedly, that too with a delay of 559 days. In the light of, as we find the explanation, there is no explanation for the inordinate delay. We are not persuaded to exercise any discretion in the matter, and accordingly, application is dismissed. Consequently, the appeal stands rejected. And the full stop. The substantial questions of law suggested are left open. Next,
Item number 24,
24 my lord, I am appearing.
Number 23.
we admitted.
He called 24.
She called 20. We have admitted 20. Appeal accepted.
But right now, my lord first order in 22.
But here, my lord, 117 days delay. তুমি চলে এসো, তুমি বলো।
What is DDDPL? Delhi Developmental. What happened to the notice served, not served?
The notice not only dispatch, not so saying.
All right.
That
List after completion of service of note. If you can inform Mr. Bhaskar Sangit. Sunil Surana appeared. You show him the tribunal's order.
My lord, I am take instruction, my lord.
Yeah, we have just adjourned it. The other matter also you.
My lord, I am giving me.
Item number 25.
This is my application.
My lord, I am opposing.
If your lordship kindly takes.
Extra order to কোন page?
ইন্টারনাল পেজ
এটা
এটা হবে 194 সেটা 23
May I take your lordship to the tribunal order, madam? Which your lordship will find in the memorandum of appeal itself.
Before that, can we see the substantial questions?
Yes, madam. Substantial questions your lordship will find.
Page
19.
9.
Whether the separate and distinct services rendered by the appellant could be treated as composite service in complete disregard to the contract and process of billing.
Section টা দেখা.
Extended period.
Yes, madam.
And they should go to the Supreme Court, my lord. They should go to the Supreme Court.
Because it's a valuation matter.
It's not a valuation, it's just a classification matter. My lord, subject to correction, my lord. The lordship kindly takes, my lord, the judgment rendered by the tribunal. Kindly take, my lord, from paragraph 1 itself. Briefly stated, the facts of the case are that the appellant Emma's mining, etc., extracting and transportation of coal, iron ore from Mrs. Mala Roy, leaseholder of so and so. The appellants were being paid a fixed rate per ton of iron ore. On scrutiny of the ST3 returns and other documents, the department has observed that the appellants have short paid service tax on transport of goods by road, mining service, site formation and clearance, excavation, earth moving, and demolition service during the period 2005-6 to 9-10. Accordingly, a show cause dated so and so was issued to the appellants demanding service tax of so and so, and under the proviso to section 73(1) of the Finance Act, while proposing to impose penalty under section 78 of the Finance Act, the show cause was adjudicated by the order in original, and then hence this appeal. Learned so and so appearing for the appellant submits that the original agreement dated 24th March 2005 and similar agreements were entered in respect of subsequent financial years, that is 6-7 to 9-10, during 2005-6 and during 6-7. The appellant did not charge or collect any consideration towards raising or lifting of iron ore and started charging the same from financial year 2007-8 onwards. Learned senior counsel has submitted a substantial portion of the activities comprised in transportation of iron ore. Therefore, the appellants entered into supplementary agreement from 2007-8, which whereby the consideration receivable by the appellants was split into mining charges 40% and transportation charges 60%. But the rate of duty is not in dispute.
But what is the nature of service?
The nature of service, matter how the tribunal has held decided the issue. Kindly take paragraph 8. Tribunal has not gone by valuation or classification.
It is
yes,
gone
kindly
by
going
terms
through
of the contract.
On going through the terms of the contract, we find essence of the contract is that the contractor, that is the appellant, shall extract iron ore from the said mine and shall deliver it exclusively to the leaseholder. In consideration thereof, the leaseholder shall pay to the contractor in the manner decided. Find that the rates are fixed for different types of iron ore. Malad, I am not going to that. We find that the supplementary agreement has been expanded to bifurcate the expenses relating to mining and transportation in the ratio of 40:60 while making payments. The contracts and supplement over the years were in identical manner. Thus, it is apparent that the contracts undertaken by the appellants are composite contracts. So, the main question arises is that whether the contracts are composite contract or the contracts are divisible contracts. It's not the rate of duty, my lord, or the classification dispute. Because, my lord, rate of duty is fixed. For mining, a separate rate. My lord, for transportation, it's a separate rate. The rates are not in dispute. It's the interpretation of the contract and whether this kind of arrangement could be treated as a composite contract or not. That is the exact issue which came up for consideration and decided by the tribunal against me. I mean, against the assessee. My lord, kindly come to page 6 of the internal page 6. Therefore, it was held in such cases, it relies on a judgment rendered by the tribunal, where my lord, the facts were not akin to the facts in hand, my lord, of the case in hand. Therefore, it was held in such cases that activity undertaken by the concerned parties would not fall under mining service. However, as seen above, the activity undertaken by the appellants is a composite activity. For the sake of interpretation and applicability of service tax, the contract cannot be vivisected. Learned senior counsel attempted to submit that as the payments are received separately for mining and transportation activities, they need to be considered as different services. We are not inclined to subscribe to this view. The terms of the contract in the instant case being categorical and the division of the amount
So
paid.
if you see the show cause notice,
Yes, my lord.
it is essentially a classification.
Yes. The lordship will kindly take, my lord, the show cause notice.
Page
But my lord,
64.
ultimately, my lord, whether it's a question, whether, my lord, it would go to
That is your defense. Yeah, the allegation was, for example, observation 2.
Yes.
It was found during the financial year 0809
Yes.
09010. Assessee paid to the transporter for receiving transport of goods by road service,
Yes.
for transport of so including loading, unloading, etc. But while discharging the tax liability under 21D5, the assessee have considered only the transportation portion of the gross value paid.
Yes.
They did not include the charges paid for loading, unloading, shifting, and in the taxable value.
Right.
These services were ancillary services to the main services, having essential character of transport of goods by road. Thus, as per the instruction, the same is classified under the category transport of goods by road under section 65-105.
Even their
I put the
submission
question to
in
myself.
the order,
I
in
put
the
the
impugned
question to
order.
myself with
There are
all
3 points.
humility, whether the matter should go, whether the appeal should be carried to the Supreme Court.
Senior can go twice a month to Supreme Court. At least twice a month.
Just 5 minutes for your lordship. Kindly, my lord, kindly bear with me.
No, their
My
own.
lord, whether the issue, whether the appeal should be preferred before the Honorable Supreme Court or before this Honorable High Court would depend on the order passed by the tribunal.
No.
My lord, kindly take.
In
my
fact,
lord,
we have decided otherwise. See, what happens is there will be 5 issues.
Right,
Here
my lord.
also extended period of limitation.
Right, my
Suppose
lord.
the tribunal has restricted it only to that issue.
Yes, yes, yes.
Well and good. But they have also examined the terms of the contract, which has a direct bearing on the nature of services.
Nature of service.
That's let us see your reply to the show cause.
Kindly take my reply.
My lord will also see the order, the impugned order, their own submissions, my lord, at paragraph 3.1.
But I take your lordship to the reply.
Internal page
It
3.
is there, reply is there, 82.
Submits that as held in so activity undertaken by appellant is correctly classifiable under GTSL.
But the contracts were vivisected. One for mining, one for my lord GTA. Their case is that it has to be treated as one single contract. That's in the nature of a composite contract. But subject to correction by your lordship, my lord, if your lordship kindly takes the language of section 35L. এলটা কোথায়?
Page number 6. Proposed notice page 64.
My lord, kindly take my lord. My lord has got 35L. My lord, subject to your lordship's kind consideration. আরেকটা বইও দিয়ে দাও।
Ultimately, the order in original also says, fail to discharge a service tax on cargo handling service for this period. Site
Well,
formation, clearance, excavation.
But that's not the issue now. Well, those issues are not before your lordship. Issue is, my lord, the mining and GTA. And the extended period of limitation.
Even in your appeal grounds, that is, you
And if your lordship, can you take my appeal grounds?
appeal statement of fact.
Appeal before says stat.
It starts at page 150.
Yes, yes, my lord, yes.
At 154, ground 8. 8, 9.
My lord, 8 is essence of contract. 9 is, my lord, again 69, 40.
Sir, we can't be, ultimately the issue boils down to under what category of service this has to be classified, whether it tantamounts to interpretation of the agreement or not. The correctness of the demand is the starting point. Essentially, we need to examine.
And only for your lordship's kind consideration, if your lordship kindly takes 35L once, my lord, for your lordship. My lord, Director Joseph, lordship has got that. Kindly take, my lord, 35L1B, because 1A is not relevant. Any order passed by the appellate tribunal, among other things, to the relating, among other things, to the determination of any question having relation to the rate of duty of excise or to the value of goods for the purposes of assessment. So, my lord, my submission, respectful submission before your lordship would be, my lord, for determining the issue as to whether appeal would lie before the Honorable Supreme Court or before your lordships in the High Court, my lord, the relevant factor, or my lord, the relevant consideration would be the judgment rendered by the tribunal. And in the judgment rendered by the tribunal, my lord, they have gone into the composite nature, or, my lord, these extensible. Yes. It's the tribunal judgment I am making submissions on the basis of the tribunal judgment.
It is better you go there, sir. This appeal is within time.
Absolutely, man, everything condoned.
All right. This appeal has been filed by the SSC under section 35 capital G of the Central Excise Act 1944. Middle bracket K. Challenging the correctness of the order dated 15th January 2020, passed by the Customs, Excise and Service Tax Appellate Tribunal, Calcutta, Eastern Zonal Bench. In Service Tax Appeal number 194 of 2020. Yes. The SSC has raised the following substantial questions of law on page 9. We have heard Mr. Leonard Senior Advocate appearing for the appellant SSC, and Mr. Vipul Advocate appearing for the appellant department, assisted by Mr. Tapan Bachal and standing counsel for the department. A preliminary objection is being raised by the Leonard Senior Advocate appearing for the department, stating that this appeal is not maintainable before this court in the light of the statutory bar under section 35 capital L of the Act. This objection is sought to be controverted by the Leonard Senior Advocate appearing for the appellant SSC by contending that the court has to look into the correctness of the order passed by the tribunal in this appeal, and they have done so in the case of considering whether the contract to be a case where the essence of the contract entered into by the appellant would be the sole consideration, apart from the fact whether the department was justified in invoking the extended period of limitation while issuing the show cause notice. In order to satisfy ourselves, we have carefully perused the entire materials placed on paper. On a full stop. On going through the show cause notice dated 19/10/2010, it is evidently clear that the issue directly falls. The issue which is to be decided is whether the services rendered by the issue to be decided is with regard to under which head the services rendered by the assessee has to be classified. Judgment. The assessee, while submitting a reply, has also sought to address this issue, and the show cause notice was adjudicated, and the adjudication authority has dealt with the classification issue and thereafter confirmed the demand. This order was tested before the appellate authority and the tribunal. Thus, essentially, the matter relates to a classification dispute, and if that be so, there is a statutory bar for this court to entertain this appeal under section 35 capital A within bracket 2 within bracket B small b of the act. For the above reason, it is held that this appeal is not maintainable before this court and accordingly stands disposed of. We just say disposed of as not maintainable.
Yes.
Before this court.
Great. My lord, then my lord, if your lordship kindly makes an observation that this will not prevent us from preferring appeal, kindly.
Needless to state that
Yes, my lord.
it will
Because
always
otherwise,
be
my lord,
open to the appellant assessee to invoke the appeal remedy provided under the act. The department is directed to return the original certified copy.
can we take back the certified copy?
Original certified copy of the impugned order passed by the tribunal after retaining a photostat copy.
Great. Great.
Next.
Item number 26.
26 is my appeal.
Service complete.
But I have served.
I appear for the port trust, that is the respondent number.
But port trust is one of the parties. I'll tell you, Lordship, this is a third party appeal.
Who's
this is a third party? We were not made party in the writ petition. The writ petition was filed on the allegation that there were certain parking lots and they are being disturbed. Now, my lord, it has been recorded in the order impugned. If your Lordship kindly takes up the memo of appeal.
Well, I will need to take because I find from the allegations.
But it says it appears that the petitioner
against port trust.
Basically, yes, basically, my lord, I tell you, Lordship, it's between the KMC and the port trust. My lord, we say this particular road is maintained by us, and for the last 30-40 years, we have been tendering it to the certain car parking agencies who and my lord, by this way, my lord, our tender is on process. Now, my lord, the learned judge records it appears that the petitioner has obtained a tender from the port trust authority for collecting fees for an area. My lord, in a particular area, there cannot be two authorities tendering on the road that car parking fees may be taken. My lord, this is where I am on. But KMC was not a party. We don't have all the documents.
Then you do one thing.
My lord.
You please serve the learned advocate who appeared for the writ petitioner.
Writ petitioner. Very good.
The learned advocate appearing for
the one thing, there's a section 5 and lift to appeal.
No, in his presence.
In his presence. I'll
the learned advocate for the appellant. No, full stop. Don't say that. I go there. This is the third party.
One indulgence I was seeking.
Municipal Corporation, who are not a party in the writ petition. Today, the learned advocate for the respondent writ petitioner is not appearing. We direct the learned advocate for the appellant to serve notice on Mr. Somopriyo Chaudhary, advocate, and Mr. Sayan Mukherjee, advocate, who appeared. Kaushik, they also appeared. Who appeared for the writ petitioner. List next week.
Next week, I'll do it by Monday. I'll do it. One thing, Lordship. I was just requesting my learned senior friend appearing for the port trust. If he could, if his junior could give me the address of this council appearing for the writ petitioner, the advocate on record, because but we were not a part in the writ petition. Because that will be the difficulty if I cannot serve them, if I cannot find them.
But
I'll try.
But the
council are there, Shomopriyo Chaudhary, we all know him. Because Kaushik Dev, these names are given here.
Names are given there. Very
We
good.
have mentioned the names. You find out, sir.
Very good. I'll do. Lordship, I'll come back on 28. Grateful to Lordship.
Next.
হ্যাঁ কি বলছেন? হ্যাঁ হ্যাঁ নামটা দিচ্ছি।
Item number 27.
I'm appearing this case, my lord. Because sir, my lord, return back with the endorsement address he cannot be located, my lord. So
148.
no, my lord, this is 148, my lord, against the order of the trial judge, my lord. The specified authority issued, my lord, that 3 years, my lord, it has to be principal chief commissioner or chief commissioner, my lord. So, my lord,
594 days.
594 days. My lordship kindly, my lord,
No.
because this issue is lordship has already passed an order, my lord, in favor of the department. But relying on
We have also dismissed your condoned delay in several other matters.
no, my lord. But after considering with Rajiv Bansal, your lordship has passed several orders, my lord.
This is all becoming wiser.
My lordship will kindly give one more chance. Well, let me find.
Sir, there is a delay of 594 days in filing the appeal. The delay is inordinate, unexplained. We have carefully gone through the affidavit filed in support of the petition, and we find the statements made therein are wholly unacceptable, and for the purpose of continuation of the inordinate delay of 594 days. Accordingly, according to the application for continued delay is dismissed. Appeal stands rejected. However, the question of law which has been canvassed by the appellant department is left open.
My lord,
next.
Item number 28.
But I'm appearing 234 days delay, my lord. So,
Your
sir,
Lordship,
Lordship
we
will-
want to file an opposition because 9 months delay is not explained in a proper manner. Your Lordship. In para, I am, Your Lordship.
Then we will fix that's the argument. We have heard so and so. The learned advocate appearing for the respondent prays for time to file affidavit in opposition. Let such affidavit be filed from 2 weeks from date. Next.
Grateful, ma'am.
Item number 29.
Item.
29.
Anybody for the state? State's appeal. Transport Department and WBTC Chairman, Principal Secretary, Transport Department shall be virtually present before this court on the adjourned date. Contempt petition, huh? No, WPO. The petitioners shall serve by hand this order on the Chairman WBTC.
My lord, I'm informing whoever is appearing.
No, before the single bench,
this was
the
a
Galib appeared for the state. And when was this order passed? I think they would have
2023.
2023. By now they would have complied with it. Otherwise, correction home. All right. List for 2 weeks. Yes.
Item number 30.
It may
But
please
I'm
your
for the
lordship, my lord. Yes, I'm grateful, my lord.
I'm for the respondent.
I prepare one short list of dates along with the relevant pages
What is
reference.
the issue? 148.
No,
It is the 148 issue, my lord. My grievances was, my lord, before the learned single judge. There is only 4 jurisdictional point was before the lordship. That first of all, in my case, the corporate insolvency proceeding has been started, and after that, successfully the resolution plan has been accepted by the NCLT. My case is for the assessment year 2016-17, and any pending proceedings for the 16-17 cannot be proceeded further after the order of the NCLT. It is a settled law by the Ghanasam Mishra judgment. When the learned single judge passed the order, he has doubted my status quo. My lord, it is very much apparent from the order, from the NCLT order, I am the corporate debtors, my lord. And in the Ghanasam Mishra's judgment, it is clearly stated that only the successful resolution applicant only take over the management of the corporate debtors. And after that, it will be revived and it will be going concern. Exactly, it is happening in my case. And I want to show the particular paragraph of the Ghanasam Mishra judgment. After that, I will come to the order of the learned single judge, my lord. Kindly come. Order because it,
the learned judge says
yes,
the petitioner could not enlighten the court as to the locus standi.
Locus, yes, my lord. Here, NRCL is the is a successful resolution applicant. It is recorded, my lord.
He has been protected.
NRCL is the successful resolution applicant. Here, the say equipments, here the petitioner is the corporate debtors, and corporate debtors has filed the writ petition. Question is, the corporate debtors can file the writ petition or not after the successful resolution plan has been accepted by the NCLT. The Ghanasam Mishra clearly cleared that position. The one matter traveled from the Jharkhand High Court to the Supreme Court, and Supreme Court says that only the successful registration applicant entered into the shoes of the corporate debtors. Only it is a change of management, nothing more. So the writ petition was dismissed by the Jharkhand High Court. It is totally erroneous. I am showing the particular paragraph of the Ghanasam Mishra judgment. After that, I am coming to my facts also. Lordship, kindly take paragraph 50 first. What is the submission before the court?
50.
50. And it is started from 50. The doctors Singhvi submitted that in the present matter, though the NCLT has approved the resolution plan on 17 April 2018, and NCLT had dismissed the appeal on 10th August 2018. Only thereafter, 17 August 2018, the reassessment order came in to be passed for the period 2012-13. He submitted that immediately after the appellant discovered about the said order, the same was challenged in a writ petition. However, the High Court, very important, my lord. However, the High Court has dismissed the petition on erroneous grounds. It is submitted that one of the grounds on which the petition is dismissed is that the Vedanta Limited, which was an aggrieved party since it was a resolution applicant. As such, the petitioner at the behest of the present application, which was a corporate debtor. Similarly, in our case also, NRCL, the successful resolution applicant, and I am the corporate debtor. Now, what is the conclusion of the Supreme Court? 151, my lord. Paragraph 151. That conclusion starts from, yes, my lord, kindly. In the judgment authored by the High Court, Mr. J, petitioner filed by the appellant were rejected on the two grounds. One, since the management of the appellant was taken over by the Vedanta on 4th July 2018, it was only the Vedanta which has the locus of the writ petitions. Now, Lordship, kindly come to the next paragraph at page 153, my lord. We have find the High Court has erred in holding that the apparent company does not have the locus of the writ petitioners, in as much as the management has taken over by the Vedanta Limited. The resolution plan is in the respect of the corporate debtors, and the successful resolution applicant only takes over the management of the corporate debtors in accordance with the resolution applicant. The resolution applicant steps into the shoes of the corporate debtors. As such, the findings of the respect would also not be sustainable in the law. It is quite similar in my case also. NRCL is a successful resolution applicant. I am the corporate debtor. Now I am revived. I am filing my return. I am filing the annual return before the ROC also. And after what more, my lord?
Actually, this defect can always be cured if you had implemented the successful resolution applicant.
Yes, my lord.
As second petitioner, matter would have been over.
So, and here, my lord, in the indirect way, learned judge
You show the 148 notice.
Yes, my lord. Lordship, before that, may I hand over the, this is because it's a voluminous petition, that is why I prepared it for your. দিচ্ছি বাবা, দাও। আরে দাও না আমার। And the recording of the learned judge about the facts also incorrect, my lord, in respect of 148 notice. Because it is recorded that after resolution plan, 148 notice has been issued. It is not like that. It is issued prior that
Let us
also.
go
I
to
am
the
coming, my
case.
lord. That 148 notice issued in down act at page 26, my lord, at page 148 notice issued.
213. No, first you go through the dates. See, the 30th of March 2023.
30th March
148 AB
2000.
issued.
30th March, the notice issues 148B issued also, my lord. I have taken one of the point of limitation also. If required, I will show that it is also barred by limitation, this notice. Anyway, next, the order passed under section 148D and notice under section 148 was issued. And immediately I came to the High Court, my lord. High Court entertained my writ petition because moratorium already started. Section 14 is there. And then they stayed up entire proceedings. And at the same time, High Court grant me the leave that when the moratorium will be withdrawn, because after the resolution it will be ceased, then I can come again into the High Court with the other jurisdictional point. That point of what I have taken here, it is a question of jurisdiction, because they don't have any right or jurisdiction to
It
proceed
is the
further.
same writ petition or a different writ petition?
This is a different writ petition and it is disposed of, my lord. Disposed of. That is the order at 326 and 329.
We'll go
After that, my lord, 11 August 2023, NCLT approved the resolution plan. And that is already recorded that how it is binding both the corporate debtors and creditors and all the parties, including the government institution also. After that, revenue asked after the 27th September 2024, revenue asked about the lifting of the moratorium. I have given the reply. I have given the reply in the relying upon the judgment of the Ghanasam Mishra that you cannot proceed on. Then they have relied upon one of the judgment which is not related to the CIRP case or like that. It is a winding up case. They have said it is a self court, that is income tax is a self court, that is it is not required to take any permission from the court for the initiation of the 148. It is a different aspect. Then again we have given the reply that your contention is incorrect. Then they asked for the further clarification. We have given the further clarification, and after that, ultimately on 31st January 2025, they have relied upon one of the judgment of the single judge of the Madras High Court that they said no, initiation can be done. The reason in the Madras High Court judgment that when the resolution plan has been accepted the NCLT, that time the demand has not been crystallized. That is why it can be done further. But it is already settled by the Bombay High Court. I will show the judgment much before that. And after that, the Delhi High Court judgment already discussed by the Madras High Court judgment already discussed by the division bench of the Delhi High Court judgment. They have overruled the order of this Madras High Court, and one of the judgment of the Gujarat High Court, they held in favor of the department. Against that, it is owing to the Supreme Court. Supreme Court stayed the proceedings. I will show the order also, my lord. Because as per section 31, any pending proceeding which is approved, that is the language of the order of the Supreme Court judgment, not only the dues which is not part of the resolution plan, it will be not only ceased, but suppose when the resolution plan has been accepted by the NCLT, that time they have only issued the 148 notice, but they have not completed. That time, that means the demand has not been crystallized. And when the demand has not been crystallized, it is not possible before the submit before the RP. So it is not possible as a part of the resolution plan. So it is their contention, it can be continued. But Supreme Court said no, it cannot be done. But resolution plan, once it is approved, it is final. And the Bombay High Court already it is cleared that it can be, the initiation should be by the department to complete the assessment proceedings. They have not done, they have failed, so it is closed. That is my case, my lord. If your lordship wants, then I can show the Madras High Court judgment. And
before that, let us see page 326.
326, my lord.
Your
yes.
earlier.
Volume 3. May I read, my lord? Counsel appearing on behalf of the petitioner submits that the petitioner under moratorium of the assessment year 2016-17 to 2019-20, as per the Insolvency Bankruptcy Code 2016, by an order dated 8 October 2021, passed by the National Company Law Tribunal, Kolkata Bench, Kolkata.
But your writ petition filed in 2023 should have been allowed.
Yes. Then it is already allowed, my lord. It is allowed, but thing is that the High Court, what the order passed, then to the extent of the moratorium, they stayed the entire proceeding. But when the resolution plan will be completed as per the law, the moratorium.
That is the final order.
That is the final order, my lord.
Oh, this is the final order.
This is it is disposed of, my lord. It is disposed of. The writ petition was disposed of. In the light of the same respondent direct to the stay their hands, not proceed with the.
You should have asked for quashing the notice.
I asked that is why in the next order, my lord, kindly take 328. I added. Next day I mentioned the matter. I added. Further at 329, it is the liberty given. Further, I make it clear that court has not gone into the issue of the jurisdiction that has been raised by the petitioner, and accordingly, petitioners held at the liberty to raise all the points once the moratorium was lifted. So moratorium lifted now. Now I have come into the court with all the jurisdictional points, including that.
But then the judgments of Supreme Court says that where is that Gyansham Mishra?
Yes. Yes,
says soon after an application is admitted under 227, nothing can be done.
Nothing can be done. Further, it is to
show that relevant paragraph. Give copy to Procedural.
Yes, I have copy. 102, my lord.
Where is the judgment?
We have submitted the judgment, my lord. We have given the judgment.
Which paragraph? You show
conclusion. 1021, my lord. Page 717.
Paragraph number?
Paragraph 1021.
102.1.
102.1. That once the resolution plan is duly approved with the adjudicating authority under subsection 1 of 31, the claims as provided in the resolution plan stands frozen and will be binding on the corporate debtor and its employees, members, also state government guarantors. On the date of approval plan, all such claims which are not part of the resolution plan shall stand extinguished.
Yes, and no person further
be entitled to initiate
continue any proceedings
in respect.
That is my case. And 138 and 148 also clear also. Paragraph 130. Not only, my lord, after the resolution plan.
So on and after 11th of August 2023,
my lord,
you can't do anything.
And not only that, on pan-India basis, all the high courts either quash the proceeding or stay. I have already enclosed all the order, including your lordship's order also.
But my lord,
your lordship already 521, 571, my lord, page 571, volume 4. I had the privilege to appear before lordship, and their appeal has been dismissed on the ground on 11 August 2020.
Only
and after that, my lord, there is a judgment of the coordinate bench of our High Court also. This is also the stray equipments is the petitioner at 577. They quash the proceeding under the GST law.
But only
thereafter, the Karnataka High Court judgment is there. They have quashed the proceedings, my lord, 579. There is a Rajasthan High Court judgment.
There is the Delhi High Court judgment.
Yes, Delhi High Court judgment, my lord. Yes. Delhi High Court judgment, duto dao. M-Tech.
In fact, in one case, we considered this judgment.
And before that, my lord, I only Supreme Court judgment. Supreme Court judgment. আচ্ছা আগে আগে দিল্লি হাইকোর্টটা দেখি। Yes, my lord. Relevant paragraph, my lord, 1, 2, 5 and 8, 9. Eta daw na. Okay. MTech develops. The petitioner imputes the notice issued under section 144B of the Income Tax Act pertaining to the assessment year 2021-22, dated 27 June 2020, as well as the consequential notice issued under section 143(2) and 142(1) of the Act, dated 28 June 2022 and 5th September 2022, respectively. The challenge is essentially mounted on the basis of section 31 of the Insolvency and Bankruptcy Code 2016, which the petitioner contending that once the resolution plan came into duly accepted, there is a bar created in terms of section 31 of the IBC would apply. The hearing in mind of the decision of the Supreme Court in the Ghansam Mr. and Sons Private Limited, the respondent would stand deprived of the jurisdiction or authority to reopen or assess income for any period prior to the approval of the resolution plan. Next, paragraph 5, my lord. The petitioner, in the terms of the provision of the Act, furnishes return for the 21 to 10 March 2022, declaring the net loss of rupees atho, and the CIRP proceeding in the meanwhile culminated in the approval of the resolution plan being approved by the NCLT on 15 March 2022, accepting a plan submitted by Messrs. So and so, which has been accepted by the committee of the creditor. It is only thereafter on 27 June 2022, the respondent choose to commence the
Come to
proceeding.
para 13. After distinguishing, after.
Yes, yes, madam.
13, after referring to SR Steel and Ghanshyam Mishra,
yes, my lord.
Middle of that paragraph. Also bear in mind, upon commencement of CIRP, petition is duly advertised in terms of the provisions made in Regulation 6, and which would thus constitute due public notice. Respondents cannot sustain the invocation of 1/4 based on their own failure to lodge a claim. In your case, public announcement was made
Already made.
11th of October 2022, and notice under 148AB was issued on 30th of March 2023.
My lord.
And so far as locus standi is concerned, he is entitled to.
Yes, ma'am, he is entitled.
So that much is
But
clear.
I am only relying on one judgment of Madras High Court of the Lordship.
That Madras High Court already considered by the Delhi High Court in the judgment, my lord, paragraph 11, my lord.
Your Lordship will kindly seize, my lord.
Now, this dictionary, it has been distinguished.
Yes, yes.
See, IBC does not contemplate
My lord.
any distinction between voluntarily approaching
yes.
the tribunal for being declared as an insolvent,
My lord.
or it is being initiated on a basis of a petition filed under the code. What is that section? 6 or 7?
6.
Section 6.
You got the IBC?
Yes, yes.
IBC বই চালাও।
Sir. Insolvency and Bankruptcy Code.
যদি না থাকে দাও।
Section 6. Persons who may initiate corporate insolvency resolution process. That is under section 6.
Under the erstwhile Presidency Towns Insolvency Act,
My lord.
there was a distinction.
My lord.
That distinction has been removed here.
My lord. Even my lord, in the NCLT order is also written, my lord, all the claims will be extinguished in all the income tax dues and all.
Section 6, you please see.
Section 6 is person who may be initiated corporate. Where any corporate debtor commits a default or financial creditors or corporate itself may initiate.
Where
insolvency.
any corporate debtor commits the
Itself.
default,
Yes, yes.
a financial creditor,
Yes, yes.
an operation creditor, or the corporate debtor themselves
Can initiate.
itself may initiate. So this artificial distinction is wrong. But whether any appeal had been filed against this decision, I think.
No, we have not filed any appeal.
They
Against the
must have-
NCLT order.
No.
No,
Decision at Madras High Court.
Madras High Court.
I checked, but I could not find out.
Where is that Gujarat High Court?
Gujarat High Court, my lord. Gujarat High Court. And Gujarat High Court এর অর্ডারটা দেবে, সুপ্রিম কোর্টের অর্ডারটা। না না, এটা সুপ্রিম কোর্টে তো গেছে, ঠিক আছে, তুমি এটা দাও, গুজরাট হাইকোর্টের জাজমেন্টটা।
Instead of waiting for a month, the law is once public announcement is made, everything is correct.
গুজরাট হাইকোর্টের জাজমেন্ট। It is page 42, my lord. Kindly come down. Why it is abbed? Page 42, last line. As no demand to be claimed was in existence when the NCLT passed the order on 1st of July 2022. And therefore, the demand which is arisen pursuant to the arisen order of 13th March 2000 cannot be said to have been extinguished. Because they could not compute, there is, so that is abbed. But it is clearly barred by section 31. And Supreme Court stayed the entire judgment.
Where is your copy of the writ petition?
The copy of the writ petition I have enclosed, my lord.
Prayer and the writ petition.
Page 72 onwards, my lord.
No, page 133.
23.
Prayer.
Oh, prayer.
133.
Oh, prayer.
133.
One 133, my lord. Oh, you have challenged the show cause also.
Page 526 is your objection. Did you raise this point in your objection?
Yes, we have taken this point, 526, about the Ghanasam Minister and others. 526 টা paper. Eta. 4. See.
You are referred to Gyansham Ruchi Soya.
তার আগে অবজেকশন আছে 526 আর তোমাকে চার্ট দিচ্ছি, এটা আমার, তুমি নিয়ে নিলে আমার মুশকিল হয়ে যাবে, তুমি ওকে দাও না একটা কপি। এই তো রে বাবা, এখানে তো আমার দিয়ে দাও। We have given the objection twice, my lord. At page 532 also. 31st December. What are not relevant at all. It is extended my time. It is more beneficial if I take the closing date.
But this code has got an overriding effect. IBC
Has the overriding effect as per 238.
238.
And income tax law also says 178 subsection 6 also.
Should we kindly see 238 first?
You can't do anything.
It is a special code, my lord. At page 95 of the Constitution, it is stated.
And you please show where is that 148 AD order?
148 D order. At page 261.
No.
D order. 148 D order. 261, my lord. And notice is 271. On that, how? Paragraph 261. Wait for it.
Now this
271 is the 148 notice, my lord.
261 is the order under 148 AD.
D.
But they have not considered this objection.
No, they have not considered. It is one of the ground also. It is one of the ground on the point of jurisdiction.
No, this is very wrong. They gave a reply, referred to the decisions. You sought for a copy of the NCLT order. Sought for clarification. They clarified it, and you don't even touch upon that issue. Please come. Why two appeals?
1920 assessment here.
Different assessment here.
These two appeals have been filed challenging the order passed by the learned single bench. No, it's here. Order passed by the learned single bench dated 7th March 2025 in two writ petitions in WPO number 141 of 2025 and the other number is WPO
142
of 2025. The impugned orders in both the writ petitions is an interim order by which the respondent income tax department were permitted to proceed further pursuant to the notice dated 24th April 2023 for two assessment years, namely 2016-17 and 2017-18. Notice date
1617 and 1920. I have prepared for the list of dates also for 1920 also.
Notices dated 24/3/2023.
It is for the 1920, my lord. 30th March 2020 is for the 1670. Only the notice date is different. Initial notice date. 148B notice.
All right. Challenging the notices issued by the respondent under section 148 capital A within bracket small b of the Income Tax Act 1961 within bracket the Act dated 30/3/2023 for the assessment year 2016-17 and 24/3/2023 for the assessment year 2019-20. The learned single bench held that the action to be taken by the department, including passing of any order, shall abide by the writ petition. Aggrieved by such order, the appellant has filed the present petition, present appeals. With the consent of the learned advocates appearing on either side, the appeals as well as both the writ petitions in WPO 141 of 2025 and 142 of 2025 are taken up for disposal. Since facts are identical and the legal issue to be decided in both the appeals are common, we take up the facts in APOT 71 of 2025, which pertains to the assessment year 2016-17. The writ petition was filed challenging the order dated 8/10/2024.
It is actually communication later, kind of later, but they have taken the decision. That is why we have, it is kind of later, kind of communication.
What is the date of AD order?
My lord, which order?
AD 261.
Oh, 261. 261, my lord, AD order.
Challenging
24th of April, 2023.
The order passed under section 148 capital A within bracket D, dated 24th April 2023, within bracket.
Assessment year 16-17.
Both the year is same. Both the date is same.
For both the assessment years. The petitioner has also impugned the consequential notice
Yes, ma'am.
issued under section 142 within bracket 1 of the Act. The first issue, which was first objection raised by the revenue, was that the appellant writ petitioner, being the corporate debtor, is not entitled to, has no locus standi to file the writ petition because a resolution plan has been approved by the National Complaint Law Tribunal by order dated 11th of August 2023. The learned single bench has recorded this objection in the impugned order. We are required to examine as to whether the objection raised by the department was sustainable.
At paragraph 151 and 153.
To decide, we need not labor much to decide this issue, as the same has been answered by the Honorable Supreme Court in the decision in Yansha Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited and others. 2020-21 9 SEC 657. In the said, the appeal arose out of an order
One 151, my lord, paragraph.
No, in the said appeal, one of the questions, one of the contention raised by the appellant was that though NCLT had approved the resolution plan on 17/4/2018 and NCLAT had dismissed the appeal on 18/8/2018, only thereafter on 17/8/2018, the reassessment order came to be passed for the period 2012-13, which was challenged in the writ petition. However, the same was dismissed on the ground that the resolution applicant therein, Messrs. Vedanta Limited, was the aggrieved person and a writ petition at the behest of the appellant before the Honorable Supreme Court, who was a corporate debtor, was not maintainable. While considering this, the Honorable Supreme Court considered this submission, and in paragraph 153 of the judgment, it was held that the High Court erred in holding that the appellant company, within bracket therein, does not have locus to file the writ petitions in as much as the management has been taken over by Messrs. Vedanta Limited. Full stop. The resolution plan is in respect of corporate debtor, and the successful resolution applicant only takes over the management of the corporate debtor in accordance with the resolution plan. Full stop. The resolution applicant steps into the shoes of the corporate debtor. Full stop. As such, the finding in this respect would also not be sustainable in law. Thus, the objection raised by the department with regard to the locus standi of the appellant writ petitioner has to necessarily fail, and accordingly the same stands rejected. The next issue is whether the department could have proceeded to pass the order under section 148 capital A within bracket small d of the Act. The note, admittedly, no, it is not in dispute that NCLT admitted the application under section 227, 239 within bracket 2 within bracket small z small k bracket close of the Insolvency and Bankruptcy Code 2016 within bracket IBC on 8/10/2021, and public announcement thereof was given on 11/10/2022. It is not in dispute that the notice under section 148 capital A within bracket small b of the Act was issued much after the public announcement, that is on 30/3/2023 for the assessment year 2016-17 and 24/3/2023 for the assessment year 2019-20. The petitioner challenged the said notices by filing writ petitions. Contending that the appellant writ petitioner was under the moratorium period and no proceedings can be initiated or continued against the appellant writ petitioner. In this regard, several decisions of the Honorable Supreme Court was relied on, as well as the decision of the division bench of this court. Taking note of this settled legal position, the writ petition was disposed of by the learned single bench of this court by order dated 20th July 2023, restraining the authorities from proceeding further pursuant to the notices issued under section 148 capital A within bracket small b of the Act. Subsequently, the case was listed for clarification, and the court by order dated 27 July 2023 made it clear that the court has not gone into the issue of jurisdiction that has been raised by the petitioner and granted liberty to raise all points of law once the moratorium is lifted. Therefore, at the earliest point of time, the petitioner was prompt in challenging the proceedings initiated by the department under section 148A within bracket B of the Act by approaching this court. And the stand taken by the petitioner was accepted, and taking note of the fact that the moratorium was in operation, the court restrained the authorities from proceeding further with the matter. Thank you. The NCLT approved the resolution plan by order dated 11th of August 2023, which was informed to the department, Income Tax Department, by the appellant petitioner on 1/10/2024. The department, by communication dated 8/10/2024, stated that the department proposes to proceed with the reassessment proceedings. No, proposes to continue with the reassessment proceedings. The petitioner filed their objection dated 28th October 2024, pointing out the legal position, referring to various decisions of the Honorable Supreme Court, and requested the authorities to drop the proceedings. Thereafter, the department sought for clarification from the petitioner by communication dated 24/12/2024, calling for the copy of the order passed by the NCLT and also to indicate the relevant paragraphs. This direction was complied with by the petitioner by submitting a reply, by submitting an online reply dated 30th December 2024, in which they reiterated the jurisdictional issue and requested to drop the proceedings. Despite the two objections given by the assessee, appellant assessee, the department proceeded to pass an order under section 148 capital A within bracket D of the Act, dated 24th April 2023. On perusal of the order, we are surprised to note that the objections regarding the jurisdiction of the authority to continue the proceedings has not been dealt with by the assessing officer, and proceeded to make certain observations on merits and held the transaction to be a bogus transaction and that it remained unexplained. The manner in which the assessing officer has passed the order dated 24/4/2023 has to be necessarily deprecated. The purpose of issuing a show cause notice is to afford an opportunity to the assessee to explain. And if the assessee has made an explanation, the assessing authority is duty bound to consider the explanation and deal with the points raised in the explanation and then proceed to record its conclusion. This basic manner, this basic principle has been lost sight of by the assessing officer while passing the order dated 24/4/2023. This ground, it would be more than sufficient to quash the said order and the entire proceedings. However, since submissions were made on either side on the other issues as well, we have examined the other contentions. Now, in this Gyansham, which is that paragraph they said they cannot continue the proceeding?
Yes, my lord. 102 at
102.
Honestram judgment of all.
Once again, we full stop. To decide the other issue as to whether the assessing officer could have continued the proceedings on and after the admission of the application by NCLT and the public announcement thereof, and after the NCLT has approved the resolution plan, we find the answer in the decision of the Honorable Supreme Court in Gansham Mishra, within bracket Supra. Wherein the Honorable Supreme Court held that once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including the central government, any state government or any local authority, guarantors and other stakeholders. Full stop. It was further held that on the date of approval of the resolution plan by the adjudicating authority, all such claims, which are not a part of the resolution plan, shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to a claim, which is not part of the resolution plan. The above the decision of the Honorable Supreme Court is would clearly apply to the facts of this case, and on and after the approval of the resolution plan, which was done on resolution plan by NCLT, which was done on 11/8/2023, the assessing authority could not have proceeded further. On this ground also, the order impugned in the writ petition is liable to be set aside. The learned advocate appearing for the revenue placed reliance on the decision of the Honorable Single Bench of the High Court of Madras in the case of Dishnet Wireless Limited versus Assistant Commissioner of Income Tax, OSD, WP number 34668 of 2018, etc., dated 17/6/2022.
Paragraph 27.
In the said decision, the Honorable Court took note of the decision in Gansham Mishra, and however drew a distinction between voluntary and involuntary insolvency and sought to distinguish the said decision and observed that the said decision has not been rendered in the context of voluntary corporate insolvency. In our, going by the scheme of IBC, we find that there is no such distinction carved out between voluntary and involuntary corporate insolvency. And the consequences also do not make any such distinction. Pursuant to a petition filed under Section 7 of the IBC. This issue was considered by the Division Bench of the High Court of Delhi in MTech Developers Private Limited versus NFAC, Delhi, WPC within bracket C 15567 of 2022, dated April 15, 2024. We agree with the view expressed by the Division Bench of the Delhi High Court of Delhi in MTech Developers Private Limited. Apart from that, it is also to be noted that in terms of section 238 of the IBC, there is an overriding effect. The said provision states, the provisions of IBC shall have effect, notwithstanding anything inconsistent therewith, contained in any other law for the time being in force, or any instrument having effect by virtue of such law.
And it is also cleared by one of the judges by the Supreme Court, one such order. I think
At this juncture, we may refer to section 178 of the Income Tax Act, 1961. More particularly, subsection 6, which states that the provisions of section 178 shall have effect notwithstanding anything to the contrary contained in any other law for the time being in force, except the provisions of the Insolvency and Bankruptcy Code 2016. What is that decision you have got?
order of this.
Thus, a conjoint reading of both the above provisions will clearly show that the provisions of IBC shall override the provisions of the Income Tax Act. In this regard, we may refer to the decision of the Honorable Supreme Court in Special Leave to Appeal C number 6483 of 2018, PCIT versus Monet, MONNET, Ispat and Energy Limited, dated 10/8/2018, wherein the Honorable Supreme Court has held that given section 238 of IBC, it is obvious that the code will override anything inconsistent contained in any other enactment, including the Income Tax Act.
One 178, 178, section 170.
Thus, for all the above reasons, we hold that the proceedings initiated by the respondent department, commencing from the issuance of notice under section 148 capital A within bracket small b of the Act and culminating in the order passed under section 148 capital A within bracket D of the Act and the consequential notice issued under section 142 within bracket 1 of the Act are ex facie without jurisdiction and unsustainable in law. For the above reasons, the appeal and the writ petitions are allowed and the orders impugned in the writ petitions are quashed.
Grateful. Both the cases. They'll not 14.
30 and 31.
30 and 31, sir.
This is accurate.
But under extreme circumstances, but may I be permitted to take your lordship's kind leave to file one appellate side application for recalling of your lordship's order. But I got the information yesterday that in a public interest litigation, your lordship has directed the administration to demolish my house. I was not made a party. But the writ petitioners, out of 24, 8 signatures were forged. But they have come before your lordship by filing this application for recalling. But 60% part of the building has been demolished yesterday. And yesterday we got the news that the order has been passed by the High Court. Grateful to your lordship. This page.
आपका अनुमति होगा तो सर बताएं।
What does he want, Andrew?
इंग्लिश में बोलो।
सर इंग्लिश हमको मालूम नहीं सर, बांग्ला और हिंदी आता है सर।
Tell him.
अच्छा। Thank you.
Original side daily list item number 32.
Lordship, I appear for the appellant in this matter. Lordship, Mr. Bag is leading me in this matter. Lordship, he is unavailable today. Lordship, I want to indicate that in the meanwhile, your Lordship, in this matter, I have challenged the 148 AD order and the 148 notice. Lordship, despite mentioning, your Lordship, the matter could not be taken up, your Lordship, and Lordship, the assessment order has been passed. Lordship, may I file that by way of supplementary affidavit, your Lordship?
Who will appear for the department?
Mr. Bhattacharya is.
So Mr. Rai was earlier appearing. Now I'm told Mr. Bhattacharya is appearing. She will kindly take this matter on Wednesday, your Lordship. Mr. Bag is not here today, Lordship, due to his personal reasons.
Now, my lord, only a short submission, my lord. My lord, in this matter, my lord, 148 AB notice was issued on 8 March 2022. 148 AD order was passed on 23rd April 2023. My lord, learned read court passed order on 14th August 2023. Now, the stay petition affirm on 16 November 2023. Now, my lord, the assessment was going to be time but on 31st March 2025. Now, my lord, my learned friend by a supplementary affidavit filing the assessment order. There was no stay by the read court. That 148 order stage, the read court found that no case made out, the petition has been dismissed. Now, he has my learned friend has to file the appeal because the assessment order has been passed. And since 8/3/2022, whenever application filed by the SEC to the reply to the 148 AB order, his case, only point on his case or her case is that the application on rectification application was pending. In that time, the reassessment proceeding has been again, that is not related to the rectification application because earlier was the assessment order was passed on bogus loan, on the account of bogus loan. Thereafter, 148 order, again 148 issued on accommodation entry of 5 crores. That is totally separate proceedings. But with that as it may, today assessment order has been passed. What remain? Nothing is remain in the petition. The
Lordship, I'm grateful, Lordship. Lordship may be given liberty to keep it.
Supplementary affidavit taken on record.
I'm providing a copy, your Lordship.
Request of the sponsor on Wednesday. Next.
Grateful, Lordship. Deeply obliged.
Item number 33.
This is our bill. If your lordship kindly takes your lordship passed an order on 28th of February 2024.
Yes. So we are only going to decide whether the writ petition was against the communication of the
Dated
CBI.
6th of January 2011. Yes.
Yes.
No, the only part which is left as to whether or not the learned judge taking restitutory determination had the jurisdiction in terms of the classification of matters to be taken with regard to CBI matters. So that is the only part left.
No.
The other part, your lordship had been pleased to
No,
hold in
against the charge memo, we have set aside that. But the challenge was to the communication sent. You please see the
Page 87. Sir.
Page 87.
Yes, this was subject matter of challenge.
This is by CBI. Therefore, the CBI matter, the learned judge had no jurisdiction determination
On that particular day.
on that particular date. We have the list showing.
First, this is the circular.
Kindly see, my lord, that this has been clarified. It is clarified.
Copy.
Copy has this matters. Copy like that.
Now, my lord, this list shows this list dated 16th November 2023. Now, this has been clarified by the Honorable then Chief Justice by order dated 30th September 2022. Writ petition which falls under both the subject description, namely secondary education and higher secondary education, will be taken up by the Honorable Judge having determination of higher secondary education. Writ petition which fall under the both subject descriptions, college is not relevant. Now, 3 matters relating to CBI and central agencies in writ petition under Article 226 of the Constitution of India are already included within the comprehensive reading of subject category police. Therefore, it is tallying with the list of 16th of November 2023.
Taking the determination of police determination.
That is on the first point.
Yes, and the learned judge
Did not have the jurisdiction.
did not have the jurisdiction to take up this matter. He was taking simplicity residuary matters.
Not police.
Residuary matters, not police matters, which is clarified. Now, your lordships are aware that in terms of 1998, 1 SCC page 1, the Supreme Court, a case which went, a very disputed case went up to Supreme Court from Rajasthan High Court, when our then Honorable Chief Justice Mukul Gopal Mukherjee, since deceased, took away the determination of a learned judge issuing rule of contempt against the Chief Justice. And that went up to Supreme Court. Supreme Court has said, no, I have only one copy.
No,
19.
I've given, yeah.
Oh, that is given. The Supreme Court has categorically stated in this judgment, it is exclusively falls within the determination of the Honorable Chief Justice, whether to assign a matter, whether to take away matter from a learned judge's determination, or a pending matter, or a pattern matter, or a contempt matter.
Which will be the relevant paragraphs?
Paragraphs
10, 16,
10, 16, 20, 23, 27, 29.
And
10, 16, 20.
10, 16, 20, 23, 27, 29, 59.
And 59.
These are these things, only thing left open for determination.
All right. Without prejudice to this, regarding the maintainability of the writ petition you have contended, as against the communication sent by CBI. That has also been gone into by the learned judge. Suppose we hold that the learned judge did not have determination, the entire order has to go. Assuming we hold, no, at the relevant time, the exercise of jurisdiction was proper, then we have to examine the merits of the matter.
Yes.
So ASG may make submissions on that also.
Not today. No, actually,
or let them answer the first point.
If the initial lack of determination is satisfied, to your lordships, or then entire thing passed by the learned judge is a nullity. Is a nullity. No further argument is to be advanced before your lordship. Your lordship prima facie holds.
All right. Then on this submission, we will hear the counsel.
Yes.
Yes, ma'am.
My lord, if the matter is then remanded back to the honorable judge having jurisdiction, it may be heard out afresh, and the order that has been passed in their favor, that may be recalled if that is the contention here. Or if my learned senior friend agrees, then we can proceed before my lords.
No, you are agreeable for the matter being sent back to the court having determination.
Unless my learned senior friend agrees for the matter to be taken up right now, I would
Yes, right now only.
prefer for the matter to be heard on merit.
In fact, 3 days or last week, there is an order that is arising out of an order passed by the Division Bench of the Calcutta High Court. That order has been set aside. Matter was directed to be placed before me to be assigned to the bench having determination. The single bench here, when it heard the matter, I think released the matter or for some reason.
Most probably Justice Basu. Most probably that matter relating to homestay.
It has come in the live law.
Possibly that is homestay matter, homestay.
Or GTA matter.
GT or GTA.
The single bench, I think.
Justice Basu.
Justice Basu. Honorable Justice Biswajit Basu.
Single bench said that one legal issue is pending before the larger bench and therefore release the matter. As against that order, an intra-court appeal was filed. Before the appellate court, both sides said we'll make submissions on merit. Recording the concession, the bench proceeded to hear the matter, rendered judgment.
Not with great respect,
that judgment was set aside and the matter has come back to me, and yesterday I have assigned it to another bench.
Kindly consider two things. One is that since a matter is pending before the larger bench, on that ground, if it is released, That is completely different from the issue raised in
No,
this.
no. Senior, I mean, your friend appearing on the other side says they'd have no objection for the matter being sent to the court having determination.
Determination. Yes, I have no objection on this issue.
Or if your lordships will take it up and hear it out, if he does not have any
It will
objection.
go before Honorable Justice Tirthankar Ghosh.
Then lordship, the order that has been passed in their favor, that may be recalled, lordship.
Which one?
The first order that was passed in this particular appeal.
No, that order we won't recall. That is against a charge memo. By way of a supplementary affidavit you came. The original challenge you will be entitled to RER. So in fact, we advised you to move the Central Administrative Tribunal on that. Earlier round you succeeded partially.
But lordship, the rest of the grounds in the writ, I may be permitted to agitate before the learned single judge.
Not in the supplementary. This intra-court appeal by the Ministry of Finance, Department of Revenue, Government of India, and the Additional Director, Central Government Health Scheme, Government of India, is directed against the order dated 19th December 2023 in WPO 1788 of 2023. The writ petition was filed by the first respondent herein for issuance of a writ of mandamus to rescind the report submitted by CBI dated 6th January 2023. That is in page 76. Which is the page number? Page number of the communication.
Communication, page 87. Page 87.
Yeah, so and so. Which was addressed to the second appellant, namely the Additional Director, Central Government Health Scheme. Along with the said communication, there were annexures which included a CBI report wherein there were allegations, facts and circumstances and the evidence revealed during investigation along with recommendations against the accused persons. The communication further states that during investigation of this case, sufficient oral and documentary evidence have come on record against the first respondent writ petitioner, who was then posted as Senior Health Administrative Assistant in CGHS, Siliguri unit, for initiating RDA major against the said official. The Additional Director, CGHS, was requested to take action against the said public servant and intimate the CBI of the same. Further, it states that the CBI report be treated as confidential document and no reference of it be made in any subsequent correspondence with any persons. Full stop. In case any applicant seeks copy of the CBI report or part thereof under the Right to Information Act, views of CBI, ACB, Kolkata should be obtained as per section 11 of the RTA Act before deciding the matter. The challenge to the said communication by the respondent writ petitioner was on the ground was in complete violation of the principles of natural justice And it was a capricious action, as no new evidence has been discovered against the respondent writ petitioner. Further, it is contended that CBI had no jurisdiction to issue the communication in view of the fact that the final report was taken on record by the concerned court, and the allegations and the alleged proceedings against the respondent writ petitioner was dropped in its entirety. Therefore, it was contended that the communication is an attempt to overreach its jurisdiction by acting in colorable exercise to the extent of jeopardizing the service and career of the respondent writ petitioner. During the pendency of the writ petition, a charge sheet was issued by the department to the respondent writ petitioner. Under the provisions of the Central Civil Services within bracket classification, control and appeal bracket close rules 1965. By a charge memorandum dated 28/11/2023. When the writ petitioner filed a supplementary affidavit and sought to challenge the charge memorandum also in the writ petition, and such prayer was acceded to by the learned single bench, and the same was also considered in the impugned order. When this appeal was heard earlier, an order was passed on 28th February 2024, by which it was held that a writ petitioner under Article 226 of the Constitution was not maintainable against a charge memorandum issued under the provisions of the Central Civil Service within bracket CCA bracket close rules 1965. Considering the fact that there are several remedies available to the respondent writ petitioner, including the remedy of approaching the Central Administrative Tribunal. Full stop. The court also noted the fact that earlier the respondent writ petitioner had challenged the order of removal from service dated 4/7/2023 by approaching the Central Administrative Tribunal, Calcutta, in OA 350/00961/2023, which was disposed of by order dated 12/9/2023. Taking into consideration all these facts, this court in the said order dated 28th February 2024 held that the writ petition was not maintainable against a charge memorandum. The operative portion of the order reads as follows. There are no paragraph numbers. Page 3, the paragraph starting after and ending with shall also remain state in page 4. Thus, what remains in this writ petition is whether the communication sent by CBI dated 6/1/2023 to the second appellant was within their jurisdiction or not sustainable for the reasons set out by the respondent writ petitioner. When this appeal was heard earlier, the learned additional Solicitor General also raised the question of jurisdiction of the concerned learned single bench, which heard the matter by contending that the writ petition would not fall within the Group 9 classification, which was being dealt with by the learned single bench at the relevant time, particularly on 19th December 2023. In this regard, the cost list of cost list of 19th December 2023, as well as the partial modification / clarification notification issued on 30th September 2022 was referred to. In support of his contention, the learned Additional Solicitor General placed reliance on the decision of the Honorable Supreme Court in State of Rajasthan versus Prakash Chand, 1998, 1 SEC, page 1. Wherein the Honorable Supreme Court held that the administrative control of the High Court vests in the Chief Justice of the High Court alone, and that it is his prerogative to distribute business of the High Court, both judicial and administrative. Full stop. He alone has the right and power to decide how the benches of the High Court are to be constituted, which judge is to sit alone, and which cases he can and is required to hear, as also to which judges shall constitute a division bench and what work those benches shall do. It was further held that the words that the judges of the High Court can sit alone or in division bench and do such work only as may be allotted to them by an order of or in accordance with the directions of the Chief Justice. As could be seen from the notification dated 30th September 2022, matters relating to CBI and central agencies in writ petition under Article 226 of the Constitution of India have been included within the comprehensive reading of subject category inverted comma police in the appellate side rules, and therefore there was no need to mention CBI and central agencies separately, and accordingly the same was deleted. Thus, a reading of this notification would show that the Group 9 classification, which deals with residuary matters, would cover cases other than cases which fall under the category inverted comma police, which include CBI and central agencies. Therefore, on the relevant date, the concerned court did not have the determination to deal with a matter concerning CBI or any central agency. As pointed out earlier, the challenge in the writ petition is to a communication issued by the CBI to the CGHS. Therefore, this would fall within the category within inverted comma police. Faced with the above situation, the learned advocate appearing for the respondent writ petitioner submitted that the order impugned may be set aside and the writ petition may be placed before the honorable bench, having determination to be heard afresh and to be heard afresh on merits and in accordance with law.
My lord, kindly grants us liberty to file a fresh writ petition annexing this order.
No. We will send. Otherwise, you lose on seniority, etc. Or you can withdraw the writ petition.
May I file a fresh writ petition if Lordship grants liberty?
What do you say, sir?
Not actually, once there are judgments right from 1960 onwards in civil suits, once a right is accrued to the party, it cannot be withdrawn without leave of the honorable court. If my lords are willing to give leave to file a fresh,
that will be easier for them.
Yes.
Secondly, you can also file your affidavit in opposition.
Yes, opposition. Yes.
Yes, sir. Submit that the writ petitioner may be permitted to withdraw the writ petition and file a fresh writ petition on the same cause of action, which may be heard by the Honorable Court having determination. The learned Additional Solicitor General appearing for the appellant submitted, such prayer can be considered with the leave of the court, and if the court and if this court decides to grant such liberty, it may do so. Another submission made by the learned advocate appearing for the respondent writ petitioner is that the earlier order passed by the division bench dated 28 February 2024, whereby it was held that the writ petition was not maintainable against a charge memorandum may be set aside. This prayer cannot be acceded to, and the prayer is rejected, as it has been held in no uncertain terms that the writ petition was not maintainable as against the charge memorandum. Therefore, even if liberty is granted, liberty should be restricted only to the challenge to the communication of CBI to the CGHS. In the light of the above, the order impugned is order passed in the writ petition is set aside, and the petitioner is permitted to withdraw this writ petition, withdraw WQ 1788 of 2023, which stands dismissed as withdrawn, and with liberty to the petitioner, respondent writ petitioner, to file a fresh writ petition on the same cause of action, namely with regard to the correctness of the communication sent by the CBI to the CGHS.
Before the appropriate bench, without having police.
Needless to state that if a challenge is made by way of a fresh writ petition, the matter shall be heard by the honorable bench having determination to hear police matters. Inverted comma, police. In the light of the above, the cost of rupees 50,000 imposed on the appellant is set aside.
Deeply obliged, my lord.
Next.
Item number 34.
Sir, 335, sir.
This is an incentive matter, and for today they have got the incentive.
But contempt is stayed. We stayed.
No. We have informed the honorable single judge that since the application.
The next matter, the secure prince, my lord, has stayed in the sense, not to take up the matter before. Secure prince, তোমাদেরটা নয়। Secure prince, দাদা তুমি সবকটা petitioner দের দাও নাকি?
So let it remain in the list. Probably it will reach.
Next Wednesday, madam.
পরে করবো আর কি করবো?
আমি বলছি আবার কোন মামলা কি করছি?
বলছি